Today, the Supreme Court struck down federal limits on how much a political party can spend in coordination with its own candidates. The court overruled a 25-year-old precedent called Colorado II. The First Amendment wins. The spending limits are gone. What I'm about to read is the official syllabus from the slip opinion, released today by the Supreme Court of the United States. This is the document. Verbatim. No commentary, no analysis, just the record. National Republican Senatorial Committee v. Federal Election Commission, case number 24621, decided June 30th, 2026. Note, the syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions for the convenience of the reader. Supreme Court of the United States. Syllabus National Republican Senatorial Committee et al. V. Federal Election Commission et al. Certiorari to the United States Court of Appeals for the Sixth Circuit. Number 24-621, argued December 9th, 2025. Decided June 30th, 2026. The Federal Election Campaign Act restricts a political party's spending on campaign activities in coordination with candidates. In 2001, this court upheld those coordinated expenditure limits as consistent with the First Amendment in Federal Election Commission v. Colorado Republican Federal Campaign Committee, known as Colorado II. Petitioners, a group of candidates and political party committees, challenged these political party coordinated expenditure limits under the First Amendment, arguing that Colorado II is no longer good law. In light of Colorado II, the en banc United States Court of Appeals for the Sixth Circuit rejected petitioners' First Amendment challenge. This court granted certiorari, held FECA's political party coordinated expenditure limits violate the First Amendment. A. The court has jurisdiction under Article 3. At the outset of the litigation, at least one of the plaintiffs, then candidate for Senate J.D. Vance, undisputedly had standing. Vice President Vance still maintains an active statement of candidacy on file with the FEC indicating his intent to run for Senate in 2028, as well as a campaign committee that has raised money for a Senate race, establishing that this dispute is justiciable. B. The First Amendment provides that Congress shall make no law abridging the freedom of speech. This court has determined that political parties, as well as candidates, private individuals, and outside groups, may make unlimited independent expenditures during political campaigns. This case concerns FECA's limits on spending by political parties in coordination with candidates. 1. FECA limits political party coordinated expenditures. FECA's limits impair the party's traditional forms of communication, such as advertisements, preclude parties from amplifying the voice of their adherents, impose additional monetary costs and burdens on political parties, and inflict a stifling effect on the ability of the party to do what it exists to do. 2. Statutory limits on contributions to candidates or parties are subject to closely drawn scrutiny. To satisfy that standard, a regulation may not be disproportionate and must be necessary and narrowly tailored to its asserted goal. The court must assess, first, the government's asserted interests in imposing the limits at issue, and second, the fit between the limits and the government's asserted interests. The political party coordinated expenditure limits fail to satisfy the closely drawn test. 3. To analyze FECA's limits on political party coordinated expenditures, the court must first assess the asserted governmental interests justifying those limits. The court's precedents recognize only one constitutionally permissible government objective for campaign finance restrictions: preventing corruption or the appearance of corruption. And Congress may target only a specific type of corruption, quid pro quo corruption. Particularly relevant here, this court has recognized the risk of quid pro quo corruption or its appearance when a donor's contributions to a political party are earmarked, that is, are directed, in some manner, to a candidate or office holder. Ultimately, the First Amendment question in this case boils down to whether FECA's limits on political party coordinated expenditures are permissible in order to prevent circumvention of the base limits on contributions to candidates through earmarked contributions to parties. In Colorado 2, this court said that they were, but Colorado 2 applied deferential scrutiny to Congress's political party coordinated expenditure limits. Since Colorado 2, however, the court has emphasized that under the closely drawn test, judicial review must be rigorous. Under that more demanding standard, the court agrees with petitioners that the political party coordinated expenditure limits are not proportionate, necessary, and narrowly tailored given the other, less speech-restrictive tools available to the government to prevent circumvention, in particular earmarking and disclosure laws. With respect to earmarking laws, FECA treats an individual's contributions to a party that are in any way earmarked or otherwise directed through an intermediary or conduit to a federal candidate as contributions from such person to such candidate, and thus subject to the limits on contributions to candidates. The court has explained that such earmarking rules constitute a targeted and constitutionally permissible way for the government to prohibit circumvention of the base limits on contributions to candidates. As Justice Thomas has explained, vigilant enforcement of the earmarking rules is a more precise response by the government to any circumvention concerns. With respect to disclosure laws, FECA requires that political parties and candidates publicly disclose both the contributions they receive and their spending on campaign activities, including on coordinated expenditures. As the court emphasized previously, disclosure has become a much stronger anti-circumvention tool over time because of modern technology, especially the Internet. Importantly, it is the combination of the base contribution limits plus the earmarking rules plus the disclosure requirements together that serve the government's anti-circumvention interests here, without unduly restricting core political party speech. Given the meaningful prophylactic measures available to combat quid pro quo corruption, or its appearance, the court concludes that the political party coordinated expenditure limits at issue here are disproportionate and are not necessary and narrowly tailored for the circumvention interest. C. Amicus and interveners contend that the court should adhere to Colorado 2 as a matter of stare decisis, but Colorado 2's reasoning has been rejected by the court's more recent precedents and is no longer good law. To the extent that Colorado 2 has retained any vitality, it is now overruled. 117 F. 4th 389, reversed and remanded. Kavanaugh, J., delivered the opinion of the court. NRSC v. FEC, decided today, June 30th, 2026. Colorado 2 is overruled. Political parties can now spend without limit in coordination with their own candidates. The full opinion is available at supremecourt.gov. If you need legal documents, living trusts, LLC operating agreements, power of attorney, go to blegalap.com. Subscribe. 3 decisions dropped today. This was the third. The record is running.